All right, good afternoon. We are going to get started and talk about the IEP process with regards to parents' rights. The first thing that I would like to review and that I'm going to send in an email to you guys today about is how to read a student's IEP. This presentation was given by Equip for Equality to discuss with parents so that they have a better understanding of what to expect when going through and reading the IEP, because it can be quite lengthy. I've seen some IEPs as short as 35 pages, some that are bigger than 50. There are a lot of different sections within each IEP. So I want to make sure that you guys are equipped with the information that you would need while reviewing a draft of the IEP before the IEP meeting happens so that you can ask questions. Like I said, again, I'm going to send this all to you in an email so that you have this presentation ready to go. But one thing is, like, the first page is just basically the student's information, your information, who is present. The information in the parent or participants' information is just who is present. By signing this, this does not mean that you agree or disagree to the IEP. It just means that you were present at the meeting to share your voice and your student's voice. The other sections will go based off of, like, I'll show you each section as to what that means and go into larger, great detail. So this is a good resource for you guys to have to go through each of the IEPs. Each time that you have an IEP, the draft needs to be sent no later than 3 days before the IEP meeting so that you can review each and every section and every information that's presented to make sure that you have your questions and concerns addressed. I recommend taking notes from there, kind of going through each section, asking those questions at the IEP. Even if you have that chance to review it, they still have to review it at the IEP. So do not let them go against that and just say, okay, we're not going to, review this information, that we're going to, go forward and you don't have any questions. If you reviewed it at home, make sure that they go section by section to help you understand. All right, I am going to go into my presentation. Let's go back so that you guys can have information about your parents' rights. Prior to the IEP or after the IEP, you should receive a notice of procedural safeguards for parents, guardians, and students with disabilities. This is incredibly jargony. It's very legalese, so to speak, and can be very long. The most recent packet is about 20 pages. It just goes through and it tells you exactly what your rights are as a parent. I'm going to send to you guys the copy from June 2022. This is the most updated and recent notice of procedural safeguards. It will go through each of the sections, including what is a prior written notice, notice in understandable language, electronic mail, giving consent, and things like that. I will go through prior written notice in a little bit in the actual slides. But one thing that you should know is that if English is not your strongest language, if it is your second language, and you have a language that is more familiar to you, whether that is written or spoken or both in the combination, the notice must be written and provided to you in a language that is native to you. Same thing for the IEP. Even though the IEP may be written in English for the school to understand and things like that, they need to provide all communications to you in your native language. So if you do speak another language and you're more comfortable having that language presented to you versus having English as that language that's presented to you for your IEP or any of your notices or anything like that, you need to make sure that the school district knows, because they do need to make sure that anything that's provided is in an understandable language to you so that you understand everything. You may choose to receive your notice by email. Prior written notice can be sent via email. Procedural safeguards notices related to a due process complaint. We'll go through what a due process complaint is at the very end, but they can send you things via email. If you prefer, they can also send it to you in the mail through your address that is on file. We're going to go through some of these sections as well, but the procedural safeguards gives information with regards to what is your parental consent. You know that we can't go forward with initial evaluations or services or reevaluations without your consent. The school district could go through and provide a reevaluation to your child without your consent, but they have to document that they have tried to contact you on 3 separate occasions in different formats, whether that's phone, email, in person, that nature, to get your consent, and they have not received that, then they can move forward with a reevaluation as long as that's all documented. Consent is voluntary. You can withdraw it at any point in time. So you may consent to it today, but then during the process, you may say, wait, hold up. I don't consent to this any further, and you can withdraw your consent at any time. That's the same thing for your consent for services too. You can say, okay, I accept this, and then, oh, nope, just kidding. I don't want to accept these services or this placement anymore. By withdrawing your consent for services and placement, that will mean that your child will no longer be receiving those services or that placement. So keep that in mind when you are talking about consent. I'm not going to go through the words of the state, as I assume that everybody that is on this presentation or who is watching this presentation does have parental rights or guardianship of their child. If you do have a word of state, contact me and I can go through the special rules for you. Parents must be present and show their presence during IEPs to have their voices heard. Again, you can do that via phone call, via Zoom meeting, or in person, but you need to make sure that you are there to provide your consent and to listen to the IEP. If you do not provide consent for the initial evaluation or fail to respond to their request, the district may, but is not required to pursue having an initial evaluation conducted using mediation and or due process hearing procedures. So that would be the only time that they could move forward with an initial evaluation, is that they would have to go through a mediation or due process agreement in order to get consent if you refuse to provide that consent or you fail to respond. Initial services, if you refuse to provide consent for that initial services or your placement, the district will not provide these services for you. And furthermore, the district may not pursue mediation or due process procedures in order to obtain a ruling that services may be provided. So, and then reevaluation, if you refuse, the district is not required to pursue override procedures through mediation or due process hearing. However, they may pursue reevaluation if made reasonable efforts to obtain your consent and you fail to respond. Like I mentioned before, you can revoke this consent at any point in time. Again, when you revoke it, you may not continue to provide the school district may not continue to provide special educational related services to your child, must provide you with a timely prior written notice consistent with IDEA regulations, may not use due process procedures, in here. Is not in violation of the requirement to make free and appropriate public education available for your child if you revoke that consent. They're not required to have an IEP meeting or develop an IEP for your child, and they're not required to amend your child's education records to remove any reference of your child's receipt of special education and related services. Parents, again, must also participate in those meetings. You've been afforded the opportunity to participate in them. And again, you can participate via phone, in person, or telehealth via Zoom. You have the right to request an interpreter to serve in that role. If you are not a strong English speaker, you can have an interpreter. You just need to make sure that the school district is aware of your need and they will provide one. If an interpreter is not available, you can cancel that meeting and reschedule it at a time that the interpreter is available. You have every right for your participation. If they provide a date and a time and it does not work for you, to go back and say, I'm sorry, that date and time will not work for me. They need to make sure that they are informing you of this meeting, but also allowing for you to have a say in when it can occur. Again, there are some timelines that we have to keep in mind with regards to when we provided our initial consent for the initial evaluation, all the way to when the IEP is developed. It needs to be no longer than 60 school days. So we do have some timelines that we have to play around with. But if the school district does come to you and say, I would like to have a meeting, and you're not available at that date and time, you can request to have it at a different date and time that works for your schedule, as long as the school district is also available for that. I'm not going to get into some of these procedural safeguards because we'll discuss some of them as we're talking about the presentation. So I'm going to go to the next one. Um, so as I mentioned before, the notice of procedural safeguards, there are 20 pages, which is quite lengthy. But ISB has also put out the parent guide for your educational rights and responsibilities, understanding special education in Illinois, and it is a lengthy 232 pages. So this is supposed to help supplement the notice of procedural safeguards by providing a little bit further information as to what all of this means, but it is even further lengthy from the other presentation. And then, this out of the way. This next one is through the Office for Students with Disabilities. This is published in 2024 for the 2024-2025 school year. It is guidance on providing special education and related services to students with disabilities pursuant to the IDEA. So this is their response, their information as to, what this means with regards to the procedural safeguards. So it goes into more detail about, what the roles and responsibilities are for each person on your IEP team, what the role of multi-tiered system of supports, that FTSS that we spoke about last time, the child find process evaluations, the process evaluations, et cetera, et cetera. So it goes into more detail as to what exactly can be found in the procedural safeguards, as well as the overall process for providing services with children with disabilities. All right, I'm going to go back to my presentation. This all the way up, so it's kind of out of the way again. Okay, so starting with the first one, prior written notice. The school district has to provide written notice after the IEP meeting as a communication tool for what they are agreeing to or not agreeing to prior to the implementation of the action. So it's called a prior written notice because they have to give you notice of what we were discussing in the IEP, what was agreed upon by the IEP team, which also includes you as the parent or guardian, as well as what we're all not agreeing to implement prior to actually implementing the services. The written notice must happen 10 days prior to the proposed or refused action, and it must include the description of the action proposed by the school district, the explanation of the decision that was made at the IEP meeting, the description of the evaluation procedure and data to support their decision, as well as timelines and dates. So the district must use this to write out their proposal to initiate or change anything in the IEP or 504, as well as when they refuse to initiate or change anything. You want to know why and what is happening that will be implemented prior to it actually being implemented. So this will come after the IEP, after you've agreed upon everything. This will just be a quick snapshot as to what was agreed upon and what was not agreed upon within the IEP. Other written notices that you may see is that 1 year prior to your child reaching 18, which is far and away, much further away from here from now, they will need to provide a notice that the rights will be transferred to the child at the age of 18. So educational rights will transfer to the student regardless of their developmental disability. It's just a law within the state of Illinois, as well as other states, that once somebody turns 18, all of their rights as an adult now start, and they are supposed to be able to make their own decisions with regards to educational rights, their health rights, their monetary rights, and things of that nature. So at the age before the age of 18, all of those educational rights are under you. You have the permission to provide, yes or no, consent or refusal. But at the age 18, the child will then take over because they are now considered an adult, unless it is otherwise determined. So If you obtain guardianship of your child or the child signs the delegation of rights to make educational decisions form to nominate someone to make those decisions on their behalf, then that individual will still be able to continue to provide consent or refusal as well as a voice to that individual. If there's a service that the child is supposed to be getting per their IEP and it hasn't happened within the 10 days of the IEP being implemented, the parents also must receive written notice that this service is not occurring. When this occurs, you may be eligible for compensatory minutes. Compensatory minutes are supposed to be something offered that is similar or the same as the services they're missing out on. So, if a student misses out on speech because their speech therapist is now on maternity leave and they're looking to hire a new speech therapist, but that person can't start for another 2 weeks, and your child will be missing out on, 60 minutes total of speech services, your child may be eligible for compensatory minutes because that IEP was not able to be implemented as written for the services that your child deserves. There have been some difficulties with written notice, like parents have the right, as I mentioned earlier, to have it presented in an understandable language. This might not be written communication for some parents. Parents that have another language may understand their language more in written, but can communicate verbally in English and understand what things are being said to them and process the information far easier than if it was written down. So we have to make sure that we're meeting the parents' needs with regards to providing written notices as well as any paperwork in their understandable language. Informed consent confirms that the parents were given all the relevant information in their native language and that they understand and agree to the activities such as holding the evaluations, holding the IEP meetings, holding a revision to the IEP, or doing a reevaluation. It must be obtained prior to any initial evaluations being presented to the child for initial services and placement to start. So any sort of speech, OT, PT, social work, as well as any educational school placements, whether it be within a cluster program, a therapeutic program, or anything of the sort. You need to obtain written consent from the parent, indicating that they're okay with that, as well as a reevaluation. As mentioned earlier about reevaluations, we'll get into that in a second. For absence of parental consent for parent rights, initial evaluation, if you refuse to an initial evaluation, say that your child goes through child find or a teacher identifies your child as having some level of need that would indicate that there might be a need to provide further IEP services, and you refuse that initial evaluation, the school can then go through mediation and due process in order to obtain that consent. And this may result in the school, if it is agreed upon, if it is found as, this is what we need to do in order to help this child, this may result in the school completing that initial evaluation without your physical consent. Mediation and due process is a very long and lengthy process. We'll get into that at the tail end of this presentation. But know that if you refuse, that the school does have the right to also potentially take you through a mediation and due process to obtain that consent. Initial services and placement, if a parent refuses services, the district just won't provide them. They won't be responsible to any rules in terms of FAPE, providing that free and appropriate public education with those services. All in all, you can't pick and choose which parts of the IEP to approve and which ones to deny. It's an all or nothing deal. However, for the parts that you don't agree with, we can work to advocate or get them changed. So even though it's an all or nothing package, that doesn't mean that there isn't some way to collaborate, find consensus as to what this should look like for the child, for the betterment of their educational services and placement. And then reevaluation, same as the initial evaluation. The only difference is if the school has made reasonable attempts to receive consent and the parent has failed to respond, they can move forward with a reevaluation without the need of going through a mediation or due process. They need to show proof that they have tried to contact you via phone, email, even through regular mail, and all contacts have not been answered to provide that parental consent for a reevaluation. After they've done that, then they can move forward with that. And again, a parent can decide at any point in time that they don't want their child to receive those services anymore. Just know that if you revoke your consent, the school is no longer responsible to provide the child any services that fall under the IDA or Section 504 once the parent makes that decision. So think about that first before, revoking your consent for implementing any of the IEP services or placement. Again, even though it's an all or nothing thing, you can pick and choose and see, like, okay, I don't agree with this. Can we come to an agreement as to what this will look like for my child? Or explain it a little further to me as to what that would look like within the school setting so that I have a better understanding. Help advocate for your child because they themselves cannot advocate for themselves. Parent participation in meetings. As I mentioned before, you can participate via phone, you can participate via Zoom, you can also participate when you're in the presence of the people all around the table. You need to receive written notice from them at least 10 days in advance of the meeting time. So you'll get a long sheet that just says, the dear parent of insert, client's name, and I'll tell you the date and time, the purpose of that meeting, where you're going to be meeting at, and who will be there. Obviously, things may change in terms of who will be there. For example, you may show up and the speech therapist is absent because she's sick that day. It's up to you whether or not you move forward with the IEP with the speech therapist not being present, or maybe they will have somebody step in and report on the speech therapist's behalf so that we can still move forward with the IEP. But they need to tell you, what the purpose of the IEP or what the purpose of the meeting is, or you're going to have it on what date, what time, and who will be there. You can bring anyone with special knowledge or expertise about your child. Doesn't matter who, they can't stop you. You could bring your neighbor, you could bring your BCBA, you could bring your child's preschool teacher, you could bring whoever you want to any of the meetings, including the initial evaluation, the reevaluations, as well as your IEP meetings. This person, is just there to help you provide more information to help in the benefit of the child. An interpreter can be present and it is legally required if it is requested. Again, if English is not your true spoken language and it's not your understandable language, then you should probably have an interpreter present who can help you to understand what is being discussed at the meeting so that you can further provide consent more strongly because you understand. Written translations of all documents must be provided in the native language. And during the meeting, parents must be able to review the document as it is being discussed. So, for example, if you are on the phone, you need to make sure that the district has some way of sending you what they're doing for the IEP, whether that is you have the draft, but as things are being made or discussed, telling you where you're at within that draft IEP and what's being changed and added as the discussion is taking place. If you're within the Zoom meeting or you're within the actual room that is having the meeting, they must project it or share it in some way, shape, or form for all participants to see during that meeting. So don't accept, for them to just like talk out loud as to what's happening. Make sure that you're able to see the IEP as changes are being made so that you can comment, ask questions, or anything like that. Again, the draft must be provided 3 days before the IEP meeting is held so that you have enough time to review each section and write down your questions and concerns for each section as as it's presented. They still have to go through each section to discuss and tell you what is in there. They can't say, okay, here's this section on accommodations and modifications. Mom, Dad, do you have any questions? No? Okay, then we're going to move forward. They need to go through the section because who knows, as they're talking about it, it might spur a question or a concern for you that you may need to have answered at that point in time. So make sure it's being reviewed in front of you. And then starting at the age of 14 and a half, there must be another written notice that one of the purposes of the meeting is to talk about a transition plan. Even though 14 and a half seems like a very young age to start thinking about transitioning after high school, it is very important to start putting steps in place to allow for that transition to happen. Each year it may change based off of progress or regression as to what that transition plan will look like. And in the beginning, it may just be, where do you see your kid in 5 or 6 years, and what will that look like, and what do we as an educational team think it will look like, and what do we need to do now to help plan for that. But we need to make sure that starting at the age of 14 and a half, that that transition plan is being put into the IEP and reviewed each year after that. The IEP team also must meet once a year to review and update the IEP. So the IEP is only good for 1 year, and then after that, it expires. So we need to make sure that the meeting is held either on or before the IEP that was held the previous year. Like I mentioned before, 3 days prior to the meeting, they provide a draft to you. And then 3 days after the meeting, the school must provide copies of all finalized documentation. Make sure that you're reviewing the finalized documentation to ensure that all changes were made that were discussed. If they're not, make sure you go back to the school and say, hey, we discussed that and it's not in here. Okay, moving on to evaluation procedures. And even though this is the parent's right, it's also talking about the child's rights within the evaluation. So the evaluation must be provided in the child's first language. So if the first language is English, it would be provided in English. If the child is primarily, bilingual and speak Spanish and English, they will determine, which is the stronger of the languages for them to understand. But they need to make sure that the child is able to participate in the evaluation in their native language. This can be tricky because many of our children do use AAC devices, and most standardized assessments were not normed for the use with AAC. So there needs to be a caveat in the report that the child used an AAC device, and this is how it is interpreted within the results. Because again, most testing and evaluations that they'll be using were not made for the use of an AAC device as a communication strategy. Schools or parents can initiate an initial evaluation. If a parent is requesting it, again, you must write it down. So sending a letter directly to the evaluation team, whether that is at the home school that your child may go to in the fall, or you're contacting the Office of Student Disabilities directly to request this, they always put it in writing. Do not trust when you pick up a phone and start calling schools and saying, hey, I'd like to request an evaluation, that would be enough. Make sure you're following through with it in writing. And then the school has 14 days to make a decision about it if an evaluation will occur. So they'll review everything that you've stated and say yes or no. We'll move forward with an initial evaluation. And then after that, after you sign consent, written consent, saying that your child can be evaluated, they have 60 school days to complete that evaluation. Many schools will probably not take that long because that's a very long process. And especially since there's so many days off that schools have with regards to, holidays, teacher institute, report card pickup, things of that nature. They want to make sure that they're getting these evaluations done as quickly as possible. Within that 60 days, they also have to have the eligibility meeting to indicate, if the child's been found eligible for services, and they also need to hold the IEP to discuss what this IEP services will look like. And then the reevaluation will happen every 3 years. So once a year, you'll get an IEP, but every 3 years, your child will be reevaluated to determine eligibility of services. It's about the same process as what they did for the initial evaluation. They'll do it again for the reevaluation. All the evaluations are different from an IEP meeting. You have to have an initial or a re-evaluation to set and drive the information that is put into the IEP to indicate progress and strengths, weaknesses, things of that nature within the IEP meeting. You can request to have an independent educational evaluation. So, this means that you can receive an evaluation from someone that you choose to go through and is not employed by the school district. And the parent is responsible for that cost. The district will not pay for it. Sometimes they may pay for it at when you do the public expense, the district will pay for the evaluation, but mostly up front, parents may be required to or responsible for the costs of an IEE. The district does not employ someone. So one ways that you, or the reasons why you may go about using an independent educational evaluation as your right. Say that you have a very specific evaluation that your child, needs to have to show their particular disability that is under the 14 approved disabilities in IDEA. And the district does not employ someone who actually can provide that or who is an expert within that. You can look to see about getting an independent educational evaluation. You disagree with the district's evaluation results, such as the scores on the evals are very low, even though performance in class may show otherwise, or they scored so high that they no longer qualify for services. So you disagree with the results that the district provided, and therefore you want to seek out an individual or independent educational evaluation. Or the evaluation that they used was incomplete or used old data, outdated data, or the data collected is inappropriate, such as the testing protocol was used for a child with autism, but it's not to be used for children with autism. So they use a test that could be, but isn't supposed to be. Parents can receive an IEE at public expense if they disagree with the findings of the evaluation. There must be a written request, and the school can either agree to this request to initiate a or they will initiate a due process hearing. So that's one thing that's a little tricky about asking for independent educational evaluations is that, the school district could say, okay, fine, we'll go forward and do this IEE. Or if they say, no, we're refusing to do that, then at that point in time, the district will initiate a due process hearing or mediation against the parents. So they have the right, just like you have the right to go to due process mediation, they also have that right for due process and mediation. Independent evaluations would, even though you would be finding and choosing the person, sometimes the district may provide you with a list of individuals that they have utilized for these certain tests. It doesn't mean that that person is, in cahoots, so to speak, with the school district and would, side on the school district of whatever they previously stated. It just means that they have found these individuals as to be experts, but you can provide anybody that you choose. You can also go about and have an independent educational evaluation done prior to, initiate an evaluation with the school district, which basically just means I went out and got my child evaluated for a certain disability or diagnoses, and here is my proof of that. It would be no different than medical practitioner providing proof of diagnosis of autism that you're providing to the educational team to show that they do have a medical diagnosis. You also have the right for private schools. So children have the right to be identified and evaluated through Child Find, even if they're attending a private school. So if you're attending a private Catholic school and you believe that your child has a disability that's impacting their ability to receive educational services within their private schools, you have the right to utilize Child Find to identify and get them evaluated through that process. However, children with disabilities are not guaranteed access to services in private schools. This will be based on what the private school has accessible. So there are some private schools that do receive federal funds to provide IEP services, whether that's a speech, OT, PT, social work services, or even special education teachers. And they can decide how to allocate these funds. This is why most private schools don't have entire special education programs, because many of them do not receive federal funding in order to help provide these services. They're relying mostly on private funding and tuition costs coming from the parents. But they might also contract with the speech OTs and PTs in order to provide those services within the schools. Child Find is open to anybody, like I said before, even if they're going to a private school, but IEP services are primarily provided within a public school because it's under a federal law. If the private school does decide to provide a service plan will have to be written. It's basically an IEP for private schools, but the big difference is that an IEP is legally binding because it's under the federal law of IDEA, and a service plan is not. It's just basically detailing that your child will receive these services for this amount of minutes within this private school placement, and this is what it'll look like. But it's not legally binding. So if they refuse to provide services or something happens, they can't be held liable to provide a free and appropriate education because the child is attending a private school. The private schools may also contract and service provider that will come in. This provider will bill their insurance the same as what we might. The school is not required to do this. And then lastly, you also have the right to homeschool your child. Homeschooled children with disabilities have a right to an evaluation and IEP just like anybody else. The same process would occur if you were enrolled in school. They would provide transportation to these services if it is dictated in the IEP. So say that your child has an IEP and they're eligible for speech services, but you're choosing to homeschool, they can still provide, if it is dictated in the IEP, transportation to receive speech services within that school. If you are going to homeschool your student, I'm including 2 links in this presentation. They do have a form, CPS does, that parents can complete to indicate that they are homeschooling their child, so that effectively, takes them out of the school system, so to speak, so that there's no truancy or anything like that with regards to the law for attending school. I'm also including a link for services and supports for children that are homeschooled. In the state of Illinois, students must be registered and attending a school the year that they turn 6. So if your child turns 6 by September 1st, they should be enrolled in a school to receive services. If they turn 6 after that, say that they turn 6 on November 1st, they don't need to be. But anybody that is 6 before or on September 1st needs to be enrolled according to the state law. I'm going to move into talking about what to do if you don't agree with something within the IEP or the evaluation process or anything of that nature. You can file a complaint with either the school or the Illinois State Board of Ed. The complaint has to be related to something that occurred within the last year. So you could wait to hold off on giving your complaint at day 364 of the IEP and then provide your complaint, which would be really crazy. And I do not recommend. As soon as you are not happy with something, I suggest that you address it right then and there so that you can get the process started. Once you file the complaint with the school or the Illinois State Board of Ed within 60 days, ISB has to carry out the investigation and give the parent an opportunity to submit additional information. So even if you went to the school then has to take your complaint and direct it to Illinois State Board of Ed, and then Illinois State Board of Ed has to then be responsible for all responding. So even if, again, like you said, and if you went directly to the school to make your complaint, they still have to report it to the state so that the state picks up the complaint and handles it further from there. Um, Ensure that the school district is responding in writing to the complaint within 45 days of receiving the complaint. So the school district has 45 days to turn it over to the state. They will also, is will allow the school district to resolve the complaint, hopefully through just having meetings with you to discuss what the issue is, seeing if you guys can come to an agreement without having to pursue something further. They'll also review all the relevant information, and then they will provide a written notice of a decision of your complaint. You can also go through mediation. Mediation is the step below due process hearing. It's designed to resolve disagreements regarding the appropriateness of special education related services to children. This will be supervised by ISB and is free for the school district and the parent. Again, both the parent or the school district can call mediation and due process against the other person. But ISB will handle all of this because we want this to be a neutral process. So it will not be done through somebody that the school district is like, I'm going to bring in my own mediator to talk this through. ISB will be the one that is supervising it and providing the person that will help in the mediation. You are allowed to have your own lawyers and or your advocates present during this process. Same thing for the school district. The school district can have their own lawyers present for this. All mediated agreements are legally binding, just like the IEP. And there is a state put policy that the last thing that was mutually agreed upon within the IEP and the services that were agreed upon will still be made available for the student. No changes will be made to the IEP or the services or the placement that they're receiving. Everything has to stay the same while this mediation is taking place. And then the next step above that is due process. And this is a legal proceeding. You don't necessarily go to court, so to speak, so you don't show up at the downtown offices, but you do show up in the presence of a hearing officer who will be gathering evidence from the parents and the school district and will make a legally binding decision. This can occur regarding the district's proposal or refusal to initiate, to make an initial or change of an IEP. You can call it due process if you don't agree upon about the school placement or the services that are offered. There's many reasons. They try to see if they can resolve the complaint first and go through mediation before you go to a due process. The process is incredibly lengthy, and do note that things can be subpoenaed. So all of your emails, your records, anything of that nature that goes back and forth between the school that talks about any of these, complaints that you have or concerns that you have will be brought up during the court of law. Within the complaint of wanting to go to due process, the school district has to contact ISB within 5 days of receiving that level of complaint. Again, when you make a regular complaint to the district, they have 45 days to turn it over to the Illinois State Board of Ed to initiate that process there. As I mentioned before, it is incredibly lengthy. At that point in time for due process, advocates usually, not that they step back, they can still help, but it's better for trained lawyers to be involved in that process so that they can help guide the parents through their rights of the law through the due process agreement. One resource that I highly recommend parents to kind of locate and utilize for themselves is the company of Equip for Equality. This agency is a non-for-profit and they advocate for individuals with disabilities for both their human and civil rights. It is not just used for children or teenagers through special education. They also weigh in and provide advocacy and advice for individuals with disabilities for workforce, further schooling, and things like that. So they provide self-advocacy assistance, legal services, public policy reforms. So they really try to ensure that rights are not just, within, our state. They're trying to help ensure that it's going across, nationwide as well. They monitor issues concerning human and civil rights for those with disabilities, and they also provide trainings both to parents, school districts, and the likes. Their website, let's see if I can click on this and go to it. I'm including it in the presentation. It can go here. Oh, there it is. Sometimes the internet's a little wonky here. But like I mentioned, I included it in the presentation. They do have a phone number and an email that you can email if you have questions or concerns. Even if you just want a little bit of advice, it doesn't even have to be legal advice. It could just be, hey, my child has an IEP coming up and I really don't understand it. Or they're talking about this level of placement or these services, and I'm not sure that that is something that my child needs, or I'm looking for assistance in understanding this a little bit further. They have a lot of great resources in here, like where to get started, what is special education services, if there's problems in the classroom you need to solve a disagreement. Like there's many sources in here for your students, as well as for yourself, like how to prepare for an IEP meeting. What is it? What's a 504, which we talked about in the first setting? What is early intervention, and then timelines, things like that. There's all kinds of services and support within here, resources for you to utilize to better understand your rights as a parent, as well as your child's rights for their educational access. Like I mentioned, I'm going to scroll down here. There is a hotline, in terms of if you have more questions, you have a helpline that you can call for 1-866-KIDS-046. You can call that. There's also a link, Get the Help You Deserve. I believe that takes you directly to a form that you can fill out to ask questions or things like that. I do know one of the biggest concerns that many parents mention is that they call and they don't get an answer back, or sometimes they send an email and it might be a while. These individuals are serving all of the Chicago area, as well as sometimes people from downstate call them to ask questions about their legal rights for the IEP services or special education services in general. So sometimes, especially in the spring, going into also the fall, they have busy times because that's when many people are trying to get IEP services started or continued, and they have a lot of questions. So sometimes they do get backlogged with information, but keep trying. I swear they're a real great resource for you to utilize to ask questions and get the help that you need with regards to advocating for your child's rights as well as your rights. Just some tips for you as parents. You can bring anyone you want to any meeting whatsoever, especially the staff that are here at CPTWC. We're here to help you through that process. We can join you for the initial evaluation to provide information about your child. We can also go to the eligibility and the IEP meeting to help provide more information of how the child does within our therapy services, just to provide more of a voice to yourself and your students. You're not required to sign an IEP or a 504 when it's presented to you. Take some time to review this document after all of the changes have been made before you sign it. It's a large document, like I said, anywhere between 30 pages to 50 plus. So it can take a very long time to review it and go section by section. Also, it's usually coming after a long day, especially if CPS does, the evaluations first, and then they go to the eligibility meeting, and then they go into the IEP. You've already been there for 3 or 4 hours. It's a lot of information in a very long day. Take the time that you need to review this to ensure that you understand everything that's being presented. When it's not signed, it's much easier to make those changes. But fear not, if you do sign it and then later on you don't agree with something, or there are concerns that are going on with your child with regards to how the intervention and the implementation is going, you can call for an IEP revision to make those changes. So it's not set in stone for the next year and you have to put up with it. There are ways that you can make revisions to an IEP by holding an IEP meeting. And you can request a meeting or a review of the IEP whenever you want, regardless of when that last meeting was. It's within your right and the rights of your child to ensure that it's being implemented the way that it's written. So if you have questions or concerns, or you feel that this goal has been met and what are we doing next, they should be calling an IEP meeting so that they can make that revision and update the goals for that. Come prepared with your concerns. I highly recommend all parents write down everything that they can think of so you have an agenda for what you want to discuss and advocate for. Pick at least your top 3 priorities. These are the things that are most important for you and your child to be successful in their educational placement. Write those down so you can ensure that they're brought up. There is a parent reporting form that I'm going to share with you guys. It has a student section also, so if your student is able to participate, they can write their strengths, their weaknesses, what they like, what they don't like, how best they learn if they're able to, communicate that information. But it's just a form to go through those same questions for yourself to kind of, think about what this looks like so that when you're coming across the meeting and everybody's present, you still have all the information that you need. In the IEP, there is a section called parent concerns, and it's usually right before they go into accommodations and modifications. What they will do is document all of your parent concerns. Sometimes they paraphrase and will just highlight, big picture, what exactly your concerns are and things like that, even though you probably went on and on about all of your concerns. They'll highlight exactly what it is. If you have something written like the IEP parent report form, or you have, just a general document that says parent concerns, ask them to include it as an addendum to the IEP so that all of your information that you presented is all part of that IEP process for your child. And then that is the end of our presentation for parent rights. I want to turn it over to you guys to see if you have any questions or any concerns that you want to bring up. Secondly, at any point in time, especially if you don't feel comfortable today addressing these questions with me in this wide audience, you can also send me an email and I'd be happy to meet with you more personally to talk through any questions or concerns that you have, whether that's about your IEP rights or the IEP process overall, or you already had an IEP and what does this mean for my child, or I don't agree with it, what are my next steps? I'd be happy to meet with you. Any questions? Okay, let's stop sharing and turn off my recording.